Trademarks are everywhere, and they may be confusing, so today we'll discuss why almost everything appears to be trademarked, and why trademarks are beneficial to both businesses and consumers. So for the history, the first legislative act concerning trademarks was passed in 1266 under the reign of Henry III, requiring all bakers to use a distinctive mark for their bread they sold. The first modern trademark laws emerged in the late 19th century. The world's first comprehensive modern trademark law was the French Manufacture and Goods Mark Act, which passed in 1857. In 1862, England passed the Merchandise Marks Act, which established consequences for companies that sold products with fake trademarks. But it did not pass a comprehensive set of trademark laws until much later, in 1905. The United States trademark law went through a few incarnations before arriving in modern times, starting from 1870. The first brand to register a trademark under U.S. Federal Trademark Act of 1970 was Avril Chemical Paint Company. In the past, it was common to know who created your goods and how they were made. You went to the blacksmith if you wanted a knife, and you knew his name and the quality he provided. Now you often don't, but trademark guarantees that you are purchasing the same product with the same quality from the brand. You will know what you will get even if you don't know the person making the product or how it was made. For example, you know for sure that two Coca-Cola bottles will taste exactly the same. So, what is a trademark? A trademark is a sign capable of distinguishing the goods or services of one enterprise from other enterprises. Trademarks are protected by intellectual property rights. This implies that the trademark can be exclusively used by its owner or licensed to other party for use in the return of payment. About function of a trademark. The rationale for granting legal protection for trademark is that they are a type of property. It demonstrates to the purchasing public a standard of quality and embodies the goodwill and advertising investment of its owner. In other words, companies expend a tremendous amount of resources to develop the product, market it to the customer, and provide customer support and back up their product with warranties. At its core, trademark law serves as a protection for customers. It reduces customers' confusion and makes it easier for them to choose and buy the products and serve their desire. Take for example, when you're buying a pair of shoes, you won't have to comb through a bunch of items that look confusingly similar to Nike, not of like or Nike or Mike. You want the Nike shoe, maybe based on past experience or company's reputation. These symbols can be used to indicate trademarks. The R and circle symbol imply that this trademark has been registered for protection with state agency. Using TM symbol means its user considers the attacked mark to be a trademark, but make no claims as to its registration status. The SM is similar to TM symbol, but it is used for services. Trademarks are symbols, and because humans can use almost anything as a symbol or device capable of carrying meaning, any sign or combination of signs that are capable of distinguishing can function as a trademark. Trademarks can be words such as craft or legal, maybe it's logo, designs such as Nike swoosh, aromas such as a brand of race car oil that smells like cherries, or sometimes it may be sound. Colors such as USP brown, Home Depot orange, Tiffany blue, and John Deere green can be registered. Containers such as the Coca-Cola bottle or this perfume bottle shaped like a human skull can also be registered as a trademark. In short, they can be almost anything that distinguishes their products from others and denotes the origins of the goods. About the distinctiveness of trademark. Generally speaking, trademarks could be either a generic mark, descriptive mark, suggestive mark, fanciful mark, or an arbitrary mark. Generic name refer to stuff like using the word orange for fruit or dog for dog or cheese for tree. Descriptive terms simply describe the good and convey an immediate idea of what the product is, such as break and bake for scored cookie dough. Suggestive marks need imagination though, or perception to arrive at an understanding of what the mark represents, like Sikh for Middle Eastern food or Fruit Loops for circular fruit-flavored breakfast cereal. Arbitrary marks are commonly used words used in unexpected way. For example, Apple for computers or Amazon for book sales or Shell for gasoline. Fanciful marks are none in dictionary words such as Google for internet search engine or Clorox for break or Kodak for film. Overall, fanciful, arbitrary, and suggestive marks receive automatic protection upon use because they are considered to be inherently distinctive. The process of registering a trademark. For Vietnamese individuals, organizations, or enterprises, they can directly file or to intellectual property representative companies for a trademark registration applicant at their National Office of Intellectual Property. For foreign individual, organizations, and enterprises, trademark registration applications can only be filed to intellectual property representative companies. To evaluate the ability of trademark protection in Vietnam, the absolute backgrounds include visible, distinctive, undeceivable, and no contrary to social ethics. In many other developed countries, trademark can be admitted under invisible form. However, technologies in Vietnam are not sufficient in order to evaluate an invisible trademark until now. About the steps of conduct trademark search and registration, here is the guideline of the process of searching and registering trademarks for goods and services in 2021 as follows. Step 1. Trademark search. In this step, registrars need to check for the feasibility of the marks through Vietnamese and international database. Many prefer hiring a law agency for this work. This step is not a mandatory step but should be taken to increase the trademark registration and save time. Step 2. Submission of trademark registration. This step includes 4 stages. First, filling a trademark registration application, in which the results come to the trademark registration declaration. Then it's come to examining formality of the application, in which the result of the second stage is acceptance of formality valid. After that is substantive examination of the application. For the result is notice of intention to grant trademark protection title and payment for granting fee. And final stage to receive certificates of trademark registration. Time limits of trademark protection. Trademarks are protected for 10 years for the filing date priority date. Enterprise can renew their protection title, and there is no limit on the number of renewal. In terms of using a trademark after being granted a trademark registration certificate, when a trademark is granted a certificate of trademark registration, if it is not used for 5 consecutive years, it will be required by another entity to terminate its validity. So for the trademark infringement, there are 4 cases. The first case is using the same trademark for identical goods or services. The use of a trademark that is identical to a registered trademark for products and services that are identical to those registered with that mark. For example, Coca-Cola is a registered trademark for the brand of soft drinks. If any party uses the Coca-Cola trademark for soft drink products, this is considered as trademark infringement. Second case is using the same trademark for similar or related goods services. When an enterprise or individual has been granted a certificate for trademark registration for product or services, the use of the same mark by another individual or organization for similar products and services are also prohibited, considered as an infringement of the trademark of the enterprise that had been granted the certificate. For example, Starbucks was granted a certificate of registration of a trademark for its coffee and tea. If any party company used a trademark of Starbucks for mineral water, the party's behavior is considered as a trademark infringement. The third case is use of similar marks for similar or related goods and services. An organization or individual using a trademark that is similar to another person or organization's trademark that has been protected for registered products and services is also considered to be infringing another object's trademark. For example, a cook is granted a Hảo Hảo trademark registration certificate for noodle product. If any company uses Hảo Hảo trademark for noodle products, it is also considered infringing. Using a trademark identical or similar to a well-known trademark. A well-known trademark is one of the objects protected by the intellectual property law. Using a trademark identical or similar to a well-known trademark for any product or services is also considered trademark infringement. For example, any individual or organization that used the well-known trademark Vincom to register for any product or services in Vietnam without the consent of the owner of the Vincom trademark will be considered illegal. So we hope this video can bring you an overview of trademark so that you will be more interested in this subject and explore more about trademark and also intellectual property. Thank you for your listening.